the healthcare proxy and power of attorney are only valid when you are alive. Upon your passing, we go to the last will and testament with a will. With the basic will, what you're doing is you are saying who you want to receive your items, and you're giving, whether it be tangible belongings or any money that you have set aside, any of your finances, you can determine who you want to have that. Most often, people will put their spouse down as the person that's going to be receiving, and the person that is going to be the executor, handling all of their wishes and making sure that anything that's been bequeathed, it goes to the correct person. Um, with a will, most people don't realize that although you have appointed an executor, they still have to go to court. Now, the executor needs to be officially appointed by the surrogate court judge. Right now, that's the Honorable Asa Mosey. She will review the will, they review the petitions to the court. And this is when you hear somebody say that their will has gone into probate. It means the court has now gone to the court has now gone over the will, and they're making sure that the proper person is appointed. Probate can last a long time. It is a minimum of 7 months. That minimum is from the date that the court approves the will and approves the executor to the time that you can actually close out the estate with the court. It's a minimum of 7 months, and that's by law for any creditors to be able to come forward and put a claim against the estate. So any beneficiaries in the will have to wait 7 months in order to actually receive anything that they are being given in the will. It's a little different when it's items. If you're giving, you know, belongings versus finances, because normally those creditors that are coming forward are just looking to get paid on something. They don't really want, somebody's clothing or furniture. They're looking for assets that really have a worth or a value behind them. Um, and these can range from medical to credit cards um, that are coming forward looking for payment. Usually the largest asset in an estate is real estate, which we'll go over in a little bit. But when real estate is involved, there's different things that the court can do that's to make sure that your creditors are paid. So if you do have creditors out there and you haven't protected the real property the way that you could have, it could be sold in order to pay those creditors. But there are ways to make your real property a non-probatable asset, which would then go around those creditors. And we'll talk a little bit about that when we get to real estate. But that's really what it means when they say that the will has gone to probate. If you don't have a will, it's just called administration. That is the difference between probate and administration, is if there is a will or not. But when it comes to what is a probatable asset, those are any things with any accounts without specific beneficiaries in them. If you have accounts with your financial planner that have a specific beneficiary, like if I put my husband on there, it would go directly to him. It would not go under the will, which means you can kind of skirt around the having to go through court and the 7 month waiting period, and it can go directly to that person. I am a huge proponent of putting beneficiaries on things so that people can get their funds a lot quicker, and you're not subject to all the timings and the wait periods that the court gives. Also, with having a will, there's kind of a division between a distributee and a beneficiary. A distributee is someone that would receive your items if there had been no will, and a beneficiary are those that you name in the will. That's the difference between them. It's not really too much more complicated than that.